Good day, Crime Talk aficionados. It is Friday, and we have another great show for you today. First, we begin with the ongoing investigation in the disappearance of Nancy Guthrie. Police detained a man who was observed driving past her residence up to 100 times during the 4 weeks of the search. We then turn to the trial in Barrow County, Georgia, where Colin Gray, the father of the accused Apalachee High School shooter, is testifying in his own defense. Then we got the murder trial of Kouri Richins in Park City, Utah. Well, it was interrupted because a spectator was removed. Wait till you hear why. In Georgia, a judge ruled that the accused killer who removed both of his eyeballs following his arrest is competent now to stand trial. In Cincinnati, a man who's been convicted of shooting his unarmed neighbor gets his sentence. And in California, we got a roommate facing poisoning charges after, once again, video shows that he was tampering with his roommate's food. We've got This Day in Legal History, our quote of the day regarding the non-indispensable man, and our dumb criminal who, during a pre-employment polygraph for the sheriff's department, well, wait till you hear his deep, dark secret. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that bell for notifications of when we go live or put up new content. And you can also listen to us anytime on any of your favorite podcasting apps, which is kind of exciting because we are close to 3 million downloads when it comes to the podcasting app. So not only do we have, like 7 million downloads here, we've got 3 million downloads on the podcasting app sites as well. So that is rather exciting, and thank you very much. Now, before we get to today's show, let me remind you, go to crimetalksearch.com. All right. This is a background subscription service. So whether you want to do one search or 1,000 searches on anyone here in the United States, you can do that. And remember, you can cancel at any time. But if somebody is coming into your life, I don't care if you're dating somebody. I don't care if you're dating someone. You're thinking about dating someone. Maybe your kids are hanging out with some, new kids. Maybe you want to check out the kid and the parents. Go to crimetalksearch.com because that report only takes a couple minutes to prepare. It is emailed to you, and you can even get updates when new information becomes available. You're going to be able to find out everything about phone numbers, social media presence, email addresses. You're going to be able to find out if somebody has a criminal history, married, divorced. Do they have to register on one of those sex offender registries, ladies and gentlemen? Most importantly, criminal history. Think about it. You go out on a date, you think the person's great, you go to crimetalksearch.com, and you find out that they do terrible things to children. Wouldn't you like to know that before you went on the date? Think about of all the cases that we've talked about in Crime Talk where somebody went on a date, somebody they met online, and they never came home. That's right. They were committing dating malpractice by not checking the person out on crimetalksearch.com. Quick Google search just doesn't do it anymore, ladies and gentlemen. You have to dig deeper. All right, let's go ahead and open the record for Friday, February 27th, 2026. And first on the docket, that's right, the Nancy Guthrie story. Police investigating the disappearance of the 84-year-old Nancy Guthrie have detained a man observed driving past her home up to 100 times in a blue SUV, stopping repeatedly near a memorial erected outside the property. Now, the incident occurred during the 4th week of the search for the mother of NBC Today Show co-host Savannah Guthrie. Now, Nancy Guthrie, who was last seen by family members on January 31st following a dinner and a game night at her eldest daughter's home, and then ultimately she failed to appear for church services on February 1st. When the police checked it out and family went to the home and checked it out, they found drops of blood that were discovered on the porch, and a doorbell camera footage captured an unidentified individual wearing a ski mask at her door in the early morning hours. Her pacemaker ceased transmitting data to linked devices shortly thereafter, obviously prompting her family to report her missing. Well, the Pima County Sheriff's Department deputies and FBI agents continue the active search. And though the Bureau has relocated to primarily command the post in Phoenix, more than 100 miles away, while maintaining a presence in Tucson. And then on February 27th, agents were observed re-examining areas of the home and the lawn that had previously been searched. And the family has offered a reward for up to $1 million for information leading to her recovery. And they've donated another $500,000 to the National Center for Missing and Exploited Children because they want to make sure there are resources. Cases can be publicized that maybe don't get the attention that Nancy Guthrie's disappearance has got. A media photographer and reporters first noticed this suspect staring at a photograph of Nancy Guthrie on his phone while slowly circling the residence. Law enforcement stopped the vehicle. The driver failed a sobriety test and was arrested on a DUI charge. No direct link to the disappearance has been established. Now, obviously, neighbors are concerned about the security, resulting in obviously a sharp increase in installations of reinforced panic rooms and even hidden safe spaces, with local firms reporting hundreds of new inquiries since the abduction became public. Now, Savannah Guthrie addressed the situation in an emotional Instagram video stating, "We need to know where she is. We need her to come home. We also know that she may be lost. She may already be gone. And if you've been waiting and you haven't been sure, let this be your sign to please come forward." So just another update. As you can see, the smallest little things regarding this case become news because people want some resolution for this case. They want this case to be solved. Next, let's go to Georgia, where Colin Gray, the father of accused Apalachee High School shooter Colt Gray, took the stand in his own defense today during the 10th day of his trial, asserting that he maintained strict household rules regarding firearms and had arranged counseling for his son hours before the September 4th shooting back in 2024, where ultimately 4 people were killed and 9 injured. So, facing 29 felony counts, including 2 charges of second-degree murder, Colin Gray described Colt as a good kid, said he was very respectful. He detailed family efforts to address bullying, mental health challenges, and custody disputes following his separation from Colt's mother, Marcy Gray. He testified that he gifted Colt a rifle for supervised hunting only, with ownership deferred until after high school graduation and turning the age of 18, and insisted there were never loaded guns in the home. Gray recounted seeking to repeat Colt's 8th grade year, enrolling him in Apalachee High School and scheduling school-based counseling for September 5th of 2024. He said, "I had a plan in place," emphasizing that he was unaware of any online threats or homicidal ideations. He broke down in tears while viewing surveillance footage of the school day leading up to the shooting. And prosecutors had rested their case the previous day after presenting a detailed timeline of warning signs, including family text and Marcy Gray's internet searches regarding parental liability in similar cases. Defense attorneys called only Colin Gray as a witness. Closing arguments are anticipated as early as Monday. Now, if convicted, Mr. Gray faces a maximum sentence of 180 years in prison. Both he and his son Colt have pled not guilty. Next, let's go to Utah for the little spectacle taking place there in the Kouri Richins trial. So proceedings in the case of the murder trial of Kouri Richins were briefly interrupted today when a juror alerted the judge that a spectator was sketching members of the jury, prompting swift confiscation of the sketchbook and the individual's ejection from the Summit County Courthouse. Now, as you may know or may not know, Miss Richins, who's 35, stands accused of fatally poisoning her husband, Eric Richins, back in March of 2022 by allegedly lacing a Moscow Mule with a legal dose of fentanyl. Now, prosecutors allege she acted to collect approximately $2 million in undisclosed life insurance policies and inherit his estate while avoiding a divorce that would have left her with nothing under a 2013 prenuptial agreement. She faces aggravated murder, attempted criminal homicide, and fraud charges. Now, the trial is expected to continue through March 26. has featured testimony regarding Richins' post-death travel, publication of a children's grief book, and alleged affair-related messages. A juror's note to the bailiff expressed that this sketch was distracting and concerning. Judge Richard Mazik ruled that no audience member may sketch jurors, citing safety concerns in a high-profile cases such as this matter. Now, Richins' attorneys issued a statement affirming her innocence and confidence that the jury will reach the appropriate verdict. She has pled not guilty and is obviously entitled to the presumption of innocence unless and until she is convicted by a jury of her peers. Next, the man who gouged out his own eyeballs. He's competent. Go figure. So a judge has ruled that Robert Keller, the man accused of stabbing Bruce Dupre to death back in October of 2024, is competent to stand trial despite self-inflicted injuries in custody that included the removal of both eyeballs and biting off part of his tongue. So Mr. Keller faces 10 charges, including malice murder, felony murder, and armed robbery stemming from the fatal stabbing in which he allegedly took the victim's vehicle and cell phone. Now, 2 independent psychiatric evaluations concluded that Keller showed no severe persisting mental illness at the time of the offense, and that his post-arrest self-harm appeared to stem from guilt or shame rather than being insane. Okay. Anyway, corrections officers testified that Keller expressed a desire to be housed in a medical facility and claimed to hear voices only to, quote, cover his ass, end quote. The court rejected the defense insanity argument. The case will proceed to trial, but no trial date has yet been scheduled. Next, let's go to Ohio, where a Cincinnati man is convicted of shooting an unarmed neighbor, finds out his sentence. So a Hamilton County jury in Ohio has convicted 26-year-old Cole Hornsby of murder and tampering with evidence after he shot his unarmed 40-year-old neighbor, Theodore Block, 12 times in the back. 12 times. All right. This case goes back to April of 2024. He then hid the firearm in his shed and claimed self-defense. Needless to say, the jury didn't buy it. So the shooting occurred on the block of Kilby Road when Mr. Block, who was babysitting his grandchildren, approached Hornsby to ask him to stop firing a muzzle-loaded rifle from his porch. After an argument, Block walked home. Witnesses included Block's wife, Kissy, testified that Hornsby pursued him, shouted an expletive, and then fired repeatedly as Block lay face down. Forensic evidence confirmed that at least one shot struck the middle of Block's back while he was in the prone position. Hornsby was sentenced then to 24 years to life by Judge Jennifer Branch. The victim's daughter described the act as cowardly during the victim impact statement. Just goes to show you, ladies and gentlemen, if you're going to claim self-defense, best way to do it is somewhere where, there's no witnesses. Did that trial once. It was a little road rage thing. Only 2 witnesses. And guess what? Only one person was showing up for trial. And so how does the government refute self-defense beyond a reasonable doubt when there's no other witness to the crime? Well, they don't. That's right. Not guilty. Next, how about California, right? What could possibly go wrong in California? Well, in Santa Clarita, California, a man sharing a Cedar Ridge Court residence has been arrested after surveillance footage allegedly captured him spraying an unidentified liquid onto his roommate's groceries, pantry staples, produce, coffee maker, and other household items. And it apparently resulted in his roommate being hospitalized with liver damage. So the roommate, Billy N. Davidson Hopper, reported ongoing unexplained illnesses prompting multiple emergency room visits. Video evidence showed the suspect concealing the container after each incident. Deputies executed a search warrant following an hour-long standoff during which a mental health evaluation team negotiated surrender back in February, just the other day. Following an hours-long standoff during which a mental health evaluation team negotiated his surrender. The suspect was cited and released pending review by the Los Angeles County District Attorney's Office. Now, there were prior police contacts back in December of 2025 and early 2026 involving similar complaints of food tampering and theft. The investigation remains active. Next, this day in legal history, February 27th, 1872, ladies and gentlemen, Charlotte E. Ray graduated from Howard University School of Law in Washington, D.C. She became the first African-American woman to receive a law degree in the United States, and shortly thereafter, the first woman admitted to the bar in the District of Columbia. Next, on this date, February 27th, 1922, the United States Supreme Court unanimously affirmed the constitutionality of the 19th Amendment to the U.S. Constitution. The ruling rejected challenges contending that the amendment, which prohibited the denial of the right to vote on the account of one's sex, infringed upon state sovereignty. Can you imagine that, ladies and gentlemen? Think about that. Today, you wouldn't think about it, but somebody said, no, women shouldn't have the right to vote because it's infringing upon the state to let women vote. Yes, somebody actually got up and made that argument in front of the United States Supreme Court. I guess they were a very highly trained lawyer to make that argument. Can you imagine going home to your wife after arguing that in front of the court? Ooh, that'd be a tough one, wouldn't it? And next, February 27th, 1951, the 22nd Amendment to the U.S. Constitution was ratified, limiting any person to election as President of the United States to no more than twice. Now, this was enacted in direct response to Franklin D. Roosevelt's 4 terms in office, and this amendment established a permanent constitutional restriction on executive tenure and reinforced principles of democratic accountability in leadership. And how about a quote dealing with something to that effect, right? How about a quote regarding the 22nd Amendment and presidential term limits? Now, during the state legislative debates surrounding the ratification of the 22nd Amendment, actually proposed by Congress in 1947, and like I said, it wasn't ratified until today in 1951, Connecticut State Representative George Ramsey articulated a foundational principle in support of formal presidential term limits. Quote, "There is no indispensable man, and if that fallacy arises, this is the end of our republic," end quote. So this very concise and profound statement encapsulates the core of the Republican government philosophy underlying the amendment, that the American democracy must not depend on the continued service of any single individual, regardless of perceived capability or crisis. It directly addressed fears that prolonged executive tenure, exemplified by Franklin D. Roosevelt's 4 elected terms, could erode institutional safeguards and foster autocratic tendencies, transforming the presidency into a de facto lifetime office. Now, if we could only get term limits for members of Congress, ladies and gentlemen, no one is indispensable. They can all be replaced. Next man up. And finally, our dumb criminal of the day. Iowa wannabe deputy confesses to some deep, dark secrets. Probably don't want to do that at the job interview. So, in one of the most spectacular cases of a hiring screen delivering precisely what is promised, a 35-year-old Iowa man's bid to become a sheriff's deputy collapsed under the weight of his own unsolicited honesty during a pre-employment lie detector test. Please meet our dumb criminal of the day. Gregory Thomas Saxon of New Virginia applied for a deputy position within the Warren County Sheriff's Office and sat for the standard polygraph examination back on November 10th at the Polk County Sheriff's Office. And when Detective Jason Sadler asked about involvement in, person and property crimes, the machine delivered an unequivocal verdict. Saxton failed, very apparent, in the examiner's clinical assessment, and rather than retreat into silence, Saxton leaned into full disclosure. He first inquired whether the dark web and deep web were one and the same, then confessed to browsing pornography on the dark web. He initially described the content as, normal stuff, before acknowledging that he had deliberately searched for and viewed illicit images of teenagers on fewer than 10 occasions. Well, guess what? Investigators presented with this gift-wrapped probable cause obtained a warrant and examined Mr. Saxton's cell phone. Forensic analysis reportedly uncovered multiple images depicting minors engaged in various sexual activity, prompting his arrest promptly on February 19th on 13 felony counts of possession of such inappropriate material. Well, Mr. Saxton was released after posting a $65,000 bond. He has a preliminary hearing on March 3rd. And the Warren County Sheriff's Office has confirmed that his application process has been permanently terminated. A little bit of an irony, as thick as the procedural drama for sure, but the very test intended to separate trustworthy candidates from the rest performing flawlessly due largely to the applicant's decision to treat the examination like a confessional booth. Ladies and gentlemen, that's what I tell you. Never do a polygraph test. It measures various things, blood pressure, stress responses, but it is a tool of interrogation. And that's exactly what this detective did. And now Mr. Saxton's going to find himself probably behind bars. And, well, he will never, ever become a police officer anywhere. All right, ladies and gentlemen, that's all we have for you today. I hope you enjoyed the show. We'll see you next week, but don't forget to check out a special we're putting up Saturday. And then we have our weekly review in case you missed anything throughout the week. Hope you enjoy it. Remember, the Constitution matters.